Well, welcome back. I hope you all enjoyed a good lunch and you're ready for another few hours of forensics. Our next speaker is a PhD in engineering. Dr. Gina Cody is with Construction Control. They are consulting engineers. And Dr. Cody has a doctorate in building engineering from Concordia University in Montreal. And she joined the buildings branch of the Ontario Ministry of Housing in 1986 to work on the development of amendments to the Ontario Building Code, which I'm sure those of you who do construction law, you're very familiar with that. And afterwards she became a partner in Construction Control, Inc. And she is an active member of the CSA. Is that the Canadian Standards Association? Okay, got that one right. And she's obviously also a professional engineer. And she's also chair of the CSA standard on tower cranes. You know, those things that they use to lift pianos and build buildings with. You're familiar with cranes, and she's the expert on that. And she's going to be speaking to us today on a number of topics. The main one is the forensic evaluation of building construction, faults and defects, and she's brought some very interesting electronic toys with her, so we'll see some what the latest in digital technology is for engineers. Please join me in welcoming Dr. Cody.
Good afternoon, and it's great to be here. Most of you had your lunch, so I Okay, I think now it's better. How many of you are involved in construction? Good, not that many, so I can say whatever I want to say. Okay, the most common litigation that arises in construction is tendering, and I will define a little bit about each one of the aspects before I get into the whole evaluation and investigation procedures. Contract disputes, delay claims, and performance failure. And this is the area where the forensic investigations will come into being. The tendering process is right at the start of any construction procedure. A consultant or a project manager gets hired by the owner. That person puts together the drawing, tender documents, and calls for bids from a number of contractors. And after the bids are received, they evaluate and award the contract. And usually the owner is the one who makes this decision. One of the common problems within the practice is if the tender papers and documents are not completely prepared or missing things. That's where the general contractor who's bidding on it looks at it and say, okay, I'm going to make a lot of money on this job because these are the things that are missing, and I can make the extras after I submit my bids. So it's very important to make sure that the bid documents are complete. And one of the things we used to do, even some of the big general contractors used to come to us prior to tendering process and will say, could you find the faults within this thing so I can evaluate how I'm going to price it? So a lot of dispute commences after the bid has been accepted as well. If the person who submits the bids makes a mistake and then goes to the owner and tells him that I made a mistake, now the actions taken by the owner. Sometimes the court says you should award the contract or you were notified in time. So that also becomes a dispute. And mainly in the government type contract, the government is obligated to be cognizant of the issues. Those issues becomes quite common in contractors taking the government to court. When the contract is awarded to the contractor, there are a number of parties in any construction contract. One is the owner. The other one is the prime consultant or the project manager that may have put all the documents together. There are a number of consultants. There is the mechanical consultant, electrical consultant, architect, structural engineer, landscape architect. You can have an interior designer, and it goes on and on. So there's so many parties involved that they may all be reporting to the owner, or they may be going through the channel of the prime consultant to the owner. So that contract becomes more confusing than when you have a two-party contract. And the obligation of so many parties towards each other becomes more complicated. And obviously the general contractor who is at the bottom, that is probably wants to make his own major profit. That's where the big dollar rests. During the course of a contract, a number of change orders gets issued. And again, that's a common issue where the dispute arises and you have to go, and forensic investigation starts that were those change orders in order, properly issued, or not. And the change order is when you have a construction and you come across and you decide, instead of putting ceramics in the front lobby, you decide to put granite. Now you have to issue a change order. The contractor has to price it. The contractor knows that he's on the site. He's not going anywhere. You're not going to bring somebody else to do that job. So he usually may try to make the most of it. On the other hand, the consultant is there to make sure that the prices that are submitted by the contractor through any change order is appropriate. So these change orders, when it gets issued and the consultant may not approve it, or the prices are exceeded what it should be, that issues become quite common in disputes as well. The contract amount may increase because you're extending the amount of work you were supposed to build 1 kilometer of roadways for the place you were requesting. Now it has gone to 1.2. How that amount gets calculated, and also the contract time, depending on what type of work is coming. Something that in any contract in construction becomes part of an issue that is all the parties have to be cognizant to make sure that they appropriately respond is when change orders are issued or work that is coming up and the consultant approves it and sends it to the owner. If you don't respond properly and promptly to the change orders, then the delay claims will be issued. And it's very common. You have a lot of scaffolding on the site. You're doing the repair of an exterior wall. You have 100 workers on the site, and all of a sudden you come across to a problem. The consultant has to issue a change order right away to tell the contractors what to do. If they don't respond, these 100 workers are sitting and doing nothing. They're costing money. The equipment on the site is costing money. So the clock starts ticking for the delay claims. The consultant may issue it properly and send it to the owner. Now the owner sits on it and tries to think about it. Is it appropriate? Should I approve it? Shouldn't I? So there is a pressure on time constantly on any construction project. And the bigger it gets, that pressure becomes more. And also the general contractor just takes its time. He's supposed to finish the job in 6 months. The It's a condominium. People have to move in, and the 6 months becomes 8 months and 9 months. And these are all the delay claims that gets into it. So all the parties involved have to be cognizant of their duties and respond appropriately very fast. The main issue on any construction problem is the performance issue. The construction is finished, you have walked in through the door, and now the building is not performing, or the project that you have built or constructed is not performing the way that you expected it to. The issues that will affect the performance could be due to appearance, the finishes within the wall, the carpet is not the way you think it should be, or the windows are not looking the way you expected them to be. So the appearance is quite important. It's not performing the way you wanted it to have been. The components, now you have a retaining wall that is settling more than what it should be. So there is a structural component within the building or the structure that you're dealing with are not performing the way they should be. There are building systems within that structure, your mechanical systems, your air exchange system, your air handling system, your heating, cooling systems, all of that are part of your building that may not be performing. The other issue is the durability. Now you have got a wood that is not as durable as what you had thought would be, or what your contract had said you're going to receive. The material they installed a cotton material that instead of lasting 12 years, now it's going to last you 3 years. So it's not causing you a damage immediately, but you know that you have a durability problem. Control of interior environment, which is your windows are leaking, your roof is leaking, you get too much air leakage through the system, through your wall assembly. These are all the problems that could arise in any construction. The first thing that a construction has to comply with, a building construction, is the Ontario Building Code. It's a thick document and it's a regulation. So it's a minimum standard. Being a regulation under the Ontario Building Code Act, you have to comply with every section of it. But sometimes it becomes impossible. So have you met the intent of the section? That's another approach, because when they say 2-inch gap in your cavity wall between your masonry and inner wide and outer wide of masonry, it's not a rocket science. The mason on the site cannot really comply with that. So have you created the clean cavity or not, that becomes the issue. But it's a document that any building has to comply with. Within the building code, there's over a few thousand standards and other regulations that you have to comply with. And that's why so many parties come together to design any building project. It's so complicated. You have mechanical systems, you have different disciplines involved in that. There could be also design errors, which is not specifically because building code doesn't tell you how to design it, specific structure. Then it comes to different standards and engineering judgment. Now the design error could cause catastrophic problem, like you don't design your beams properly, or your systems are under-designed for your mechanical ventilation system. The other common problem is the construction deficiencies, which is obvious construction gaps. You know, it's a Friday afternoon, the workers want to go home, so the mason just patches up this stuff and you don't see it. It's all behind the wall, so you don't see them, you're gone, and it comes to being after you occupy the building. There is a difference between a brand new construction and if you come and do a renovation or alteration to an existing building. For alteration, you really don't have to comply with complete Ontario Building Code. That comes into being for new construction only. There's a Part 11 which refers to renovation that only applies for existing building. But there are other documents. One is Ontario Fire Code that always, at all times, every building has to comply with it. Local bylaws, different municipalities, they have different requirements for height of railing, for example. Some of them require you to comply with the building code. Some of them say it's okay, you can have it as long as you haven't touched it. You can leave it the way it is. It's quite different the way they look at different requirements, which is prescriptive requirement within the code itself, within each municipality. And before the amalgamation in Toronto, like Scarborough, City of Toronto, North York, they were all completely different on many issues. When we deal with construction defects, there could be latent defects that are within the wall assembly, or if you're looking at the beam, you wouldn't know that the reinforcing bars are not there, or is it properly designed or not. But there are the visible one when there's a crack on the wall. Everybody can see it. It's quite obvious as a deficiency. The damage that is caused by those defects could be immediate, that you can see it. The stairs have tilted. You know, it's obvious that it's a trip hazard. The person could fall. Or it could be in the future because you know that caulking that was supposed to last 12 years is going to fail in 2 years now. And you're going to start getting leakage. So again, you have to establish what issues are and when they're coming to adversely affect the performance of the building. The main issue, what is the proof of damage? Where is the damage? And how you're going to prove it. Prove the damage, which where the investigation procedures come into being. The simple way is you walk around and you record the facts. And the trained eyes usually can pick up more than an untrained eyes. When we pick up, for example, look at a deficiency in a room, I can send one of my engineers and he picks up 100 deficiency. The other guy walks in and picks up 10. So they know what to look at and where to look at on recording the facts. So you have to have a trained eyes for each specific component. And something that in the construction becomes more of importance in different people have got different expertise in different areas. You cannot be jack of all trades. So you need a group of people when you're looking at the whole building. If you're looking at a specific component, let's say you have a problem with your concrete performance, then there is a concrete expert that looks at it and evaluates what are the problems. Visual review is the common and the first step in establishing any problem within any construction deficiency. The other one is the design review. You look at a slab or a design of a structure. You can sit down and review the whole design. Was it properly designed or not? If I'm getting cracks within that slab, is it due to improper design? Or is it because it's badly constructed? Or it's missing something? Or it was overloaded immediately after it was poured. So there are many criteria that can affect the performance of just the small slab that we are dealing with. So the design review allows you to establish, was it initially properly designed? Does it comply with codes and standards? And after you have established all these issues, then you go into the forensic investigation. Why is it happening? Why am I getting cracks? Why there is mold in the walls? What is causing that? The first step is destructive testing, which is if you have a concrete slab, you can take a core sample. You drill it and you remove it, take it to the lab, you test it, you find out what is the compressive strength of that core. You can find what type of salt is in it, what type of chemical you have in it, cement ratio and water ratios, is there air in it. You can establish all the chemical components within every equipment or materials that are used within a building assembly. There are also non-destructive testing. Later on I will show you, I have brought a thermographic scan with me, and I show you how it works. So non-destructive testing, you don't have to touch anything, and you can establish the problems. Or you can carry out air testing. If you're dealing with a wall, smoke testing, you can do ultrasonic testing. When we are dealing with steel structures, that's a common equipment that is used. You look at with the ultrasonic equipment, and you can say what is the thickness of the material, is there rust within the wall, inside the material. It gives you a lot of information. You can do x-rays of all kinds of equipments. There's all the technology that exists for hospitals or medical systems, now they are within the engineering practice. The other common practice is to monitor. If you have a crack within a wall, you can monitor and establish how it is moving. And there are instruments that you can install and measures up to thousands of a millimeter movement. So you can leave it there and come back and say, yeah, in summer the crack is getting smaller, in winter it's getting wider, or vice versa. And that gives you, is it the thermal shrinkage crack? Is it a creep deflection? What type of deflection is causing those cracks? If you look at different components of a building, there are different methods utilized for doing your investigation. If you're looking at the exterior wall, you can visually inspect it from ground. You go on balconies and roof and poke your head out and try to see what are the problems. Something that we commonly use at our office, we use Bolton chairs. You have seen the window cleaners. They go on a chair up and down cleaning the windows. So we have our engineers hang on those, and they go and they wash the window at the same time. You're supposed to laugh. Anyway, so they can establish what is the condition of the wall by going down a chair or a swing stage just from the top of the building down. So you can see the entire elevation from close. And you take your photographs, you can take your videos, you can take sample of material while you are going down, and you can establish how that deficiency varies from the top of the building to the bottom. You can do testing. There are specific procedures, ASTM and CSA, which is the ASTM is the American standard for testing of materials, and CSA is the Canadian Standards Association. We have our own standards, and wherever we don't have a standard, we usually refer to the ASTM part of it. So we use the American standards for that. And for all types of different testing, there's already established testing criteria. So you can follow specific procedures for your testing. Most of them are available. There may be some that you have to create because of non-existence of that problem or that testing. You can do the airflow testing. You create big chambers and suck air, and we have all these kind of equipment. And you can use aircraft engine to create big suctions, and you can even measure the whole air leakage in a whole building by sucking air out of it. Or you send in air, you pressurize the whole building, and measure at the leak locations where the air is coming out. The water testing, we normally use it practically on regular basis to establish if you have a leakage within your specific location in your office. The most fastest way to establish where is that leak location is by doing water testing. And it could be as simple as taking a hose in your hand and zooming in and seeing where the water leak is coming. And a lot of it could be process of elimination. Relative humidity. Condensation is one of the big problems in new buildings. Causes mold, causes different indoor air quality problems. So you can easily measure the humidity level within the area, and that establishes if you have high relative humidity within a unit, the chances of mold creation is much higher. I go to many condominium units that they complain about mold presence. And when you go in, they have a 1,200 square feet of a condo, which is built very well. So it's very tight. In old times, we used to make them leak like a sieve. Now we have so much inspection and procedures in place that our walls are very tight. Our windows are better than they used to be. So now we have this airtight unit. They cook there, they take showers, and they have a humidifier, most of them. They think it's just better to create more humidity. And they have plants, and all of a sudden you go walk in and you measure relative humidity around 70 to 80%. No building is constructed for that. So you get water dripping everywhere, and because of that extensive dampness on the wall, mold starts being built up at corners. And then you get black stuff everywhere, and then it's a big dilemma what to do with the unit. And all you need to do is open the window, let the air out, achieve some air leakage. It could be as simple as that. Test cuts within the wall would tell you, are you missing insulation? Is there any problem? And then after you establish it, you open it up and you can see it. Within the walls, you have anchorage system. You have walls where precast panels are hanging. Those precast panels may weigh a few thousand pounds, and they have just 2 anchorages. So you want to make sure that after 10 years, 15 years, some of those anchorages are looked at, so the bolts that are securing it are properly in place. So you do a test cut, and you look at them. And again, thermographic scan, which is a thermal imaging of different materials. And that tells you if there is deficiencies. Windows is a common problem, whether it's a curtain wall system, like the way you see Royal Bank or TD Bank, those are all curtain wall system. And the reason they call it a curtain wall is because it's like a curtain. It just hangs there. It doesn't carry any weight. They're just going all around the building like a curtain. And it's common throughout downtown Toronto and any office building in North America. And mainly there are window glazing systems that are hanging. And again, there are certain procedures to establish, is there water penetration, is there air leakage, how do you establish the structural performance of the components, and condensation. There is established values that the components have to comply with. The same thing with roofs, different components. There has been many legal cases relating to roofs because there has been materials that came to the market and they were not as durable as everybody thought they would, and it went for many years. And if you're looking at a 800,000 square feet of industrial plant, that roof is a big number. And it mainly becomes an issue if you're dealing with industrial establishments, which varies from 100 to 1.5 million square feet of just roof. And again, the same procedures. We have another equipment within the office, which is a radioactive equipment, and you can measure how much moisture is within your roof. How do you do the recording of the problems that you come across? Videotaping. Now they're all digital videos, so you can hook it up to your computer and becomes part of your report. Thermal imaging, again, it is all digital now. It becomes part of your report. You can take a digital photograph as well as digital thermal image of the wall assembly. You can look at it and it tells you where the leakage are occurring around the windows, how much, by what percentage. You can prepare drawings establishing the locations. If you're looking at a garage roof slab, where the leak location, what performance are at different areas within that graph you're looking at. Photographs, now they're all digital. Everybody in our office carries a digital camera. They put it right on the report, and it just becomes part of the report. It all gets transferred into a PDF file, and we can email it to our clients or whoever we are working for. So the whole technology is developing quite fast and rapid. And obviously, you have to do your test results and the inspection notes. So there is all kinds of different methods of recording the problems. A standard report, when we prepare for court or as an expert report, we try to have the terms of reference, so it establishes what was the criteria that we were looking at, what was the available document, what did they give us, and what they decided not to give us. What are the standards and codes that apply to what we are looking at? What are the relevant standards? A lot of cases you go to court and the other side is looking at a standard that is totally irrelevant to the construction that you're looking at. Because the building code that applies would be the building code applicable at the time of construction. If it was 1986, that one applies, not the 1993 or 1998 code. So you have to be careful, or the standard that was available at that time. What's the history of the problem? What's the observations made during our investigation? The test results, both whatever was carried on the site and in the lab. The discussion section, why it's happening, the conclusions, and giving an opinion what caused the problem and what is the extent of that problem. What's the proof of the damage and how much that damage is going to cost. What's that associated cost? In some of the litigation procedures, it becomes important to establish how the problem arises by making small models. I was involved as the expert for the coroner when the Skyway Bridge accident occurred, and there were a number of people killed on that, and there was a scaffolding that was installed under the bridge. They were doing the repair, and it just took over. I was trying to even show to the people who I was dealing with, the police, they couldn't understand it. So the easiest way was I went back to the office, and we started putting together a couple of pieces of wood, buying a couple of chains, and we created the whole scaffolding. And you could show by just using curtain rod and very simple system. But it was so interesting, and the jurors could understand. The jury was totally fascinated how this accident occurred, because you could model it easily, and they could touch it. And they could see these are the beams, and when we talk about the joist and main beam and the hanger system and the chain, what do we mean by each one of them? Where are they located? So that type of modeling becomes very interesting when you're dealing with a little bit complicated cases. I had another case where it was a complication of a structure. the whole claim was, and it was dragging up with a number of years, and it was a steel structure that our client was claiming that it had become much more complex than what he had bid for initially, based on the sketches. And that, by the time we got involved, it was very difficult to establish how you can show it, because it was, the amount of material hadn't changed, but the location of the beam had changed. So what we did is, again, made a simple model of the first one versus a simple model of the second one. And we just chose a couple of bays of the structure because it was a huge one, and obviously the case was a large amount of money was involved in it. And by looking at the two models, simple model, you could establish, yes, this is much more complex than that. Something that we couldn't establish by words or by explaining. It just became, the more you try to explain it, the more complex it becomes. So using models or similar simulation of the events becomes very important in establishing a case. Something I have brought with me is a thermographic scan. And that's the warm-up. And if you look, this is something that the American military uses, and we purchase it through the, I will, something, if I, actually, if I point at one of you, and actually, Elliot, if you can put your hands on, I'm over it, on a table, and I just zoom at the table. This is your hand. Now take it away. And you see this image of his hand on the table, just how sensitive it is because of the temperature differential.
So this could work in absolute darkness?
Yes, and you have to use it mainly in the dark. This is close to, I think, 50,000.
What you're seeing is what, heat?
It's made by temperature, and I have a gun here, but it doesn't shoot. And I can point at whatever image I am, and you see? And it gives me right away what temperature is that. And from 1,000, you can look as far as you can stand, and I can zoom, you can see on the wall. That tells me what's the temperature of that point is. So any thermal image you see, you can point at it and find out what temperature it is and compare it to the right beside it and right beside it. So you calibrate it quite fast, and you can see the temperature differential. So now if you're looking at a building, or you want to find what's the hot spot on somebody's, your friends, so you can find out. But it establishes the, on a wall, here, like you have a precise wall, and you have to calibrate it, and it has to be after dark. We usually do it after the sun has set. So it's constant. There is no difference. You see that there is a difference. You see the metal there? That's a different image. So you see the hot spot? It's total different conductivity. That's correct. Now, if you go outside, from inside, if you're inside the building in the middle of the hallway, so you don't see much of a temperature differential there, but you can see there's a point, there's a joint there. See where these speakers are installed? These are the speakers. See, the TV obviously has got much more different conductivity. And you can calibrate it the way you want it, higher sensitivity or lower. And when you go outside in the exterior, you look at it, it's much more evident. Now if I look at the windows there, you can see, oops, sorry, I pull out. When you go outside and you look at a building 20th story or 50th story up. You can establish from the 50th story above, are you missing insulation? If you're complaining about the air leakage right above, you can establish right down on the ground where the leakage is occurring. And from the interior as well, you can go in within the exterior walls and establish the locations where insulation is missing. If you have mold problem within the wall, you want to know what's causing it, or you have anchorage problem, you can detect it, and it gives you some way of evaluating the locations versus other issues that are maybe affecting the performance. For electrical panels, for example, that's the only way you can establish. You open up a main panel on an electrical switch, you wouldn't be able to say which one is giving more electricity than it should be. So to establish a hot spot, you just open it up, you look at it with the camera, and tells you if you have a short circuit within the big panel. So that's commonly we use it for thermographic scan of the electrical panels, which by visual inspection you just don't see anything. And I think that's about it. If you have any questions, I will be pleased to answer. Yes?
In the last 5 years in rent evaluation buildings, things like that development, what's the biggest area for the good and the bad?
Yes. The construction is improving, especially in Ontario. It's because of the number of litigations and so on in the past. Everybody wants to build a better building, but one of the major problems within the industry has been the window performance. Windows, yes, and it gives a lot of, even in the most expensive buildings that we are working on, that's the main issue. There are only a few contractors who are building them, manufacturing them, so you're stuck. Most of them went bankrupt during after the last boom, in the last recession. So there's only few left, and they can't just produce, so the product is not as good. And that's where the issues that are becoming of importance, and are they important or not, is mold issue. Is becoming a common problem, and it's put totally out of proportion. It's just not what it is. But unfortunately, it's a common. And when I give talks on mold, I always tell them, if you leave your coffee cup on Friday and you come back on Monday morning, there's mold on it. You see it. You leave a green pepper in fridge too long, there's mold in it. So daily practices, you will get mold, and we don't die of those. And if you go to any old basement, there's mold in there. You can smell it. It's just the minute you walk in there. But new construction is suffering from it because of the airtightness of the building. So people don't operate the way they should. They create the mold, and then it becomes an issue. I was just actually mentioning that. I went to a site just a week ago. An owner had distributed to it. It's just finished construction. It's a big development, and one of the bigger builders. And the issue was one of the owners didn't like the developer, so sent this letter to everybody that we have got mold in our basement. So they had a big gathering, and I went with a number of professors from the university, and we were all looking, and they were all different experts in mold and specimens and different issues. And all it was, in the basement, some of the timber, when had been brought from the lumber yard, had sat on the yard for a couple of days, so it rained during that period. So it got stained, just a little black stain mark. And these guys went ahead and built the building. And these are in the basements. And you can see these black marks on them. But there was a whole riot. They had special meetings. And so there is a lot of non-issues that become an issue. I've been to Victoria and BC quite a lot over the past year, over the whole leaky condo problem. And again, the biggest problem is the mold issue there. And it has become such a stigma attached to building industry there that you can't sell your unit if you own a condo unless you have spent $1 million on it. So these poor guys, owners, they're all spending money just to be able to sell it. Because as a unit owner, you don't come and buy a unit that hasn't gone through that whole exercise of, so it has been blown way out of proportion. I was in a development that is beautiful. It's right by the water in Victoria. And it is an upper end development. And these poor guys, they made a mistake. They had an evaluation done by an engineer who told them you have mold problem. So now they're stuck. They have to spend money, and there's nothing wrong in the building. And where they found the mold was within the balcony railing outside the habitable space. So what? You have mold, but you don't live there. It's outside. It's a balcony area, and it's just constantly. And there in Victoria, you can see growth of mothballs over roofs because it just rains so much and it's so humid. But that's one of the big issues, and unfortunately, a lot of engineers try to not to be as, they don't want to take responsibility. So the easiest way is to say, okay, repair it. And then the owners are stuck with it. Yes? Actually, this is a very interesting question. 10 years ago, we did no work for banks. Now I do practically 50% of my time is spent on lenders. And that is, you cannot get a mortgage unless you have two evaluations done. One is environmental audit, and the other one is building condition assessment. 5-6 years ago was mainly phase 1 environmental, which is phase 1 environmental is an environmental engineer looking at the building and telling you what was the history behind this building. Was it used as a factory? Is there a gas station adjacent to it? And by looking at that history, we'll say there is a potential for environmental hazard or not. So that was the only thing. But now they have gone beyond that, and since the last 4 or 5 years, they want an evaluation of the roof, of the structure. Even I just had one before I came here this morning that they are lending $4 million for a renovation within an office building, which has got nothing to do with the structure. But the bank called me. I had somebody there looking at the roof and the structure, and they want to be sure that this $4 million you're spending is spent where it should be. And even the locations that they are not asking for money, they want to make sure that those are okay. And the bigger portfolios, like real estate investment trusts, which I work with a number of them, they all require evaluation. And because of the trustees involved, even after the work is done, we have to document what the stage is, and on a regular basis, we have to go back to the buildings and give them. It's a good source of income for us. Any other questions? Thank you.
Thank you very much.
Thank you.
Well, our next speaker is Mr. Wayne Crawford. And Mr. Crawford will be speaking to us about forensic appraisals. Mr. Crawford, come on down. I always wanted to say that. Mr. Crawford has been an independent practitioner and a member of the Appraisal Institute of Canada since 1979. He was granted the use of the CRA designation in 1985 and the AACI accreditation in 1988, and he'll tell us what all those letters and initials mean. He is on the executive committee of the Toronto chapter, and he's also on the National Governing Council of the Appraisal Institute. He served on certain executive boards and has delivered professional development seminars and delivers the liability insurance claims prevention portion of the mandatory appraisal standards seminar. Now, he is a president and a senior partner of a company called Appraisal Group Inc., which is a Toronto-based real estate appraisal firm, and which has a qualified staff of appraisers. We had Mr. Crawford speak to the Institute of Law Clerks fellowship course on appraisals, and he told us about a number of very interesting expropriation and damage claim cases that he had. His firm does litigation support, forensic review, and we're talking here about the valuation of property. We're not talking about the construction of it, but in effect, what is the real estate worth and why is it worth that? And Mr. Crawford has been an expert witness in court. He has given testimony at a number of different levels of court. And he's not only given evidence as to the value, but he's also refuted other experts' reports and criticized and critiqued other experts' reports to show why their valuations were not necessarily accurate, why he would disagree with their valuations. So there is a definite forensic analysis issue there too. Without further ado, I want to introduce you to Mr. Crawford, and I'll pass over the mic to him. Thank you, sir.
Good afternoon. Take up some PowerPoint.
The President, there is material here in the books. Did you bring material with
I
you?
brought the Mylar. Do they have an overhead here?
Oh, an overhead, sure. We'll just get an overhead.
It's typically not a good time to be a speaker at these seminars. Everybody's had a full day, I would assume, and I noted you had a lunch at 2 o'clock, so it should just be kicking in. One of the things, I've read the course material and the other lectures, what they brought forward. Unfortunately, I wasn't able to attend to see. But I guess what it boils down to, the whole concept of forensic anything, is one of the things that the forensic expert, either in accounting, in building construction, in appraisal, in just about anything, the value that we bring to the table sometimes is unfair to the people who originally did the work, if you think about it. How many people in this room have ever ordered a real estate appraisal? Typically, it's the last thing ordered, isn't it? Everything else is taken care of. They make sure that the EAs are done, the building inspections are done, everybody checks the leases, the routes, titles, everything, and then the oversight occurs. We need an appraisal. So typically the practitioner who goes out and delivers the appraisal must do it in a very quick format, must be done quickly, and the problem is that value stands forever. Once you put it on paper, it's there. And it's the type of thing where the forensic appraiser now, somebody's recognized that there's a problem, and they now hire an expert to do a retrospective evaluation of that expert's document. We're generally not under any major time constraints. They will phone you up and say, we need something in the next several months. This is the case. This is the problem that we have. Can you assist us in this? It's actually a luxury assignment, forensic appraisal. I really enjoy it because it's the type of thing where I not only get to do the criticism of the other person's work, either technical or administrative reviews, but the thing is I have the luxury of time. I also know the sequence of events that have occurred immediately after the appraisal was done, prior to. I have the ability to analyze sales that the other person may not have had a chance to look at, because sometimes there are sales that are going on. As we're speaking this afternoon, there are deals that have been negotiated, they haven't been closed, they're waiting to come down, and they may be the best information and data that that appraiser could use. But he can't use them because they aren't bona fide, they aren't registered. They're private sales. Typically, the appraiser tries to use MLS information, because if you use MLS information, you at least have factual data. impressions, interpretations. Typically, for example, take a house appraisal. The appraiser never gets to see the inside of the comparable sales that he's using to describe for the subject property. If anyone came to your door and said, "Hi, I'm doing an appraisal of a building down the street, do you mind if I have a quick run through your house?" It's not going to happen. They won't let you in. Similarly with buildings. Trespass laws. In the past, an appraiser could go out. For example, you'd be doing a difficult assignment where you needed to accurately measure buildings. Now with trespass laws, neighborhood watch, pit bulls, Rottweilers, you can't do it. So you're standing out there in the street now trying to visualize with your eye just how big this property is. And at the end of the day, some expert like myself comes along and says, "You were wrong." But how wrong were you? Anyway, all of the information I have and will be putting up on this is in your books. And what we're going to do is, typically I like to put the information up on here. You can either follow through in your books or just see what's happening on the screen. As I lead off with, the forensic appraiser's role is to investigate, assess factual data, check methodology, and ascertain the reasonableness of the conclusions. It is really not the forensic appraiser to come in and give you a number, because a lot of times these things have been analyzed and put together a number of times. There's already divergent opinion as to value on the property, and all I'm going to do is bring something to the mix and create another number. You may not even want my number if you're a lawyer. You may be very satisfied with the numbers that are there. You want to manipulate and massage them, and you don't want me to give you a fixed number. So I believe the primary role is not to reach that conclusion, but to support the litigation, helping you expose the weaknesses in the other appraiser's work, other expert documentation, their methodologies. So really what my job is to educate you people as to where the strengths and weaknesses are in that appraiser, in his data, how he got it, did he do thorough background checks, make you understand the process that's used, and once you understand the facts, you can now start separating the fiction, because a lot of appraisal is opinion evidence. The primary roles, as we show up there, is fraud examination as a litigation consultant and as an expert witness, and each of these will be discussed throughout the next little while. They are very distinct disciplines, because you can have somebody who is excellent in terms of finding factual data, research, and skills, but you'd never get them on a stand. It's amazing how many appraisers will not go to court. If you're engaging an appraiser for a litigation assignment, make sure this person can handle it in court. Some of these people get in court and they just go numb, or they don't want it at all. If you tell them they have to go to court, they'll decline the assignment. Okay, in terms of fraud investigation, and I think the underlying theme here is with anything, there's never really one absolute value for a property. An appraisal is opinion. There is a range of value concluded. The thing is, how bona fide is the range? You know, if you're going out looking at homes within a specific area, industrial buildings, office buildings, certain ranges are established by the units of value that are used to measure. For example, if you're involved in retail or commercial type properties, it's the rental income stream that is going to define your range. Is this property worth $10 a square foot, $15 a square foot? If you conclude that that's your range, you got a 50% margin of error. Where do you fit within the range? So when you're dealing with a fairly broad range, you've got problems there. Okay, the other things that come along in terms of fraud and whether fraud is going to be developed is the terms of the engagement. A good example, I guess most of the people here heard of the Ontario Realty Corporation land sales, where a developer bought some land and on closing he flips it. The property escalates wildly in value. The taxpayers of Ontario feel they've been ripped off. But what the press fails to report in a lot of these instances is that, notwithstanding that the sale was concluded in June of 2000, it was negotiated 2 years prior. that the person, knowing that he had a deal, took it through the development process, did a number of things, that on the date of closing, the value of the property was there. But they don't know that from the terms of reference. Okay? The other thing is terms of engagement. 1 day prior to draft plan approval. This is something that almost all levels of government like to use. In other words, it's a nice principle, but does it really stand the test of time? For example, you're dealing with residential land, industrial land, in any of the municipalities. The land is in agricultural use, and now they're moving it through the development process, and they're going to put a plan of subdivision on it. How they want you to appraise it is 1 day prior to. What that means is, notwithstanding the fact that a plan of subdivision is going on the next day, they would like you to treat it as if it was agricultural land with long-term potential. It's ludicrous. It's good for them because they're buying. But if you're selling, you're going to get ripped. So this is the type of term of reference I'm talking about. For example, assuming 100% occupancy. There are some buildings that will never achieve 100% occupancy. There were office buildings downtown in the core where zero net effective rents were structured. There was mammoth vacancies. The home office concept, does everybody remember that? We were all going to go home and work at home. We all became very unproductive. We didn't have the interplay with our mates. And now look at where the vacancy levels are in apartment and just about any type of real estate. People have had to get back into the workplace. Upon completion of certain specifications and built to a lower standard, I mean, that's self-explanatory. Somebody comes into you and says, I'm going to build a luxury home, and then they finish it with standard material. It's been appraised on the basis of luxury finishing. Therefore, the value at the end has got to be less because you didn't build to your specification. That needs to be addressed. Value in exchange. The two concepts in terms of real estate. One is called a value in exchange, and the one immediately below it is what they call value in use. The value in exchange is, if I have a home, and you're looking for a home, and they're in the same plan of subdivision, or in the same geographic region, it's a 4-bedroom home. You're going to weigh the common and discrepant characteristics between the two homes, and at the end of the day, you're going to say, for $275,000, I like this one over that one. And that's what they call the value in exchange. That's the underlying principle of most real estate transactions. Now, a value in use usually occurs when an expropriation is going to be coming down the pipe. Or you may have a disability, and you, in your home, put in ramps, elevators, whatever. On a value and exchange basis, you've got a very small market now, because most people don't need that. On a value and use basis, these things cost a lot of money. Therefore, your value and use basis will have additional value beyond market value. If that's going to form the basis of a litigation, you better be sure that you can support it. Hang in there, man. You better do something, I'll have to whisper. Are we back on? Okay. Okay, and the final section on there is fraud. I mean, there's nothing anyone can do about that. You're going out there and somebody gives you certain factual data that you believe to be true. Sometimes there's no way of independently verifying this information other than this has been provided by the client. He's stating that this is the information, this is what's going to happen, here's the sequence of events. And at the end of the day, none of them become true. What can you do as a professional? Basically, if I did the original appraisal and I had certain information provided to me, I'm going to have to follow through on that. At the end of the day, what the court's going to determine, was it reasonable what I did? Was there support for what I did? Or did I knowingly get involved in this. So you have to be very careful there. Now, as I said earlier, there's two principles that are really important for you people to understand, and I've got them marked up here. First one is the principle of highest and best use, and the second is the principle of substitution. Now, in terms of the principle of substitution, that was the original section that I was talking about. And there it is. What that essentially states is that when a property is replaceable, its value tends to be set as the cost to acquire similar property of equal desirability and utility. I mean, it's something that everybody recognizes and understands, and it's the underlying premise of most good real estate appraisal, because most people are involved when they're doing something. You can see it. If somebody's trying to sell you an apple and it turns out to be an orange, you can readily identify that, hold it, that isn't what you're offering me. It's the same when you're going out looking at real estate. If somebody is telling you that this is a modern, well-maintained property, and you walk in there and there's nothing to indicate any of this has gone on, then would you really want to compare it to other properties? Okay, so the principle of substitution is very important. What you have to do in the principle of substitution, obviously, is look at location, similar characteristics, and the foreseeable benefits of that property. Okay, one of the other things involved in the principle of substitution is there should be some consistency to the marketplace when this is going on. If you're buying property during boom periods, anyone here ever buy a property back in 1988 and 89? The market was escalating. No appraiser could stay up with the data. You would sit there and see your own home rising $25,000 a week, and the only thing that was making it happen was panic buying and speculation. When it came crashing down, all the banks, trust companies, institutions wanted to attack the appraiser, but at the same time, when we weren't supporting the deals, they were saying we're not staying up with the market. So it depends where you are at the time that this is going on and what data you have to support it. If you are supporting a sale or some type of transfer at a specified amount, say for example, pick a number like $200,000, you must have market support for that $200,000 number. You can't have all of the comparable properties, because are they truly comparable, at 150 and then say, but this is 200,000 because I say so. The market determines value, not the appraiser. So that's very important to know. And the upper limit of value tends to be indicated by the cost of producing through new construction an equally desirable substitute property. If you're involved in real estate, you hear it all the time. The net effective rents that are going on out there right now are supporting new construction. Why would anyone build a building if it costs $60 a square foot to build if you're only going to get $2 a square foot rent? It doesn't make sense. So that is an important factor to keep in mind. Okay, the other slide is highest and best use. And once again, where this is critical is this eliminates the fraud aspect, because notwithstanding what the property's current use is, what is the highest and best use? And is that use something that's legally permissible, physically feasible? Is there a demand for it? And does it provide maximum utility back to the landowner? Okay, and once again, this is in your handouts. Now, the reason why each of these factors become important, particularly in raw land, because I would think basically raw land forms the biggest part of most litigations. Because what happens is it is very volatile. It's the first to go up and the first to go down in real estate. Because people want to buy land. A lot of home builders buy land for land banking for future development. And then when the market turns, they try to divest themselves of the land. Depending on how current their purchase is, are they going to get that money out when they try to sell? If there's no demand for housing, why would there be a demand for your land that is owned for housing? Physically possible. Some people would like you to believe that certain lots you can put the Taj Mahal on, but you can't. Zoning constraints say there must be side yard setbacks, rear yard setbacks, various land use controls and regulations must be adhered to. If you have a section of land, somebody wants to put something on it, say an office building. When you go to the zoning bylaw and the official plan, you'll see whether that's physically and legally possible. Is it feasible? You can go build an office building, but if there's no demand, what's the point? You're going to have vacant space. Nobody wants to be in it, and you'll be selling it at bargain basement rates. Right now, all sectors of the economy are basically humming along nicely. I can't name a real estate that isn't going up in value. Industrial real estate since 1996 has gone up over 60%. The retail sector of the economy has done very well. Housing has gone up almost straight line because times are good. People aren't worried about their jobs anymore. Interest rates are good. Everything is just working nicely. If we have an economic downturn, you're going to start seeing the skids come on these things. So an important thing whenever you're involved in these types of things is not only what are the sales, what are the listings? If you're involved in real estate transactions where all of your sales were $250,000 and now on the market are very similar properties at $225,000, that's got to tell you something. You have extended marketing periods, there's a dry up in the demand side, and once that happens, things start moving the wrong way. I guess we should finish this section here. Okay, in terms of problems that we run into under fraud will be the symptoms of fraud. And what are they? They should be readily available because one of the things that you're doing, you're involved in litigation support. So is there overvaluation? Is there mortgage fraud? Syndications were very good for overvaluation. Because everybody was selling a piece of the pie to you. You only had to put down a little bit of money, property appreciation, investors, hot markets, everything was going to make everything real hunky-dory at the end. And matrimonial, they are the classic cases of where you have over and undervaluation. If you think about it, in a matrimonial dispute, someone has to buy out the other. So one side buys a witness to bring it in high, another side buys a witness to bring it in low. You people involved in the litigation side of things have got to try and figure out where the happy median is. Somebody hopes you split it in the middle. Somebody's going to lose. What is the value of the property? Typically in these litigations, you're best to have at least 2 appraisals done. The appraiser should be operating under the same mandate. In other words, provide me with your estimate of value. And they should all be working with the same factual information. One appraiser goes into the property and is told that there are no problems. Everything's fine. He comes in, renders his value. It's considered high. Because the other appraiser was told there's UFFI, we got termite infection. Every spring you can swim in the basement. Something's leaking. If the other appraiser had known that, he'd have made the adjustments. Sometimes they aren't forthcoming with the information. When you get into commercial, retail, inaccurate income and expense information, exaggerated income projections. If you're dealing with a startup building and somebody says, in fact, there was a good case of fraud out in Pickering over this, and it just shows you the fine line sometimes the appraisers have to walk. Somebody was building a very large retail mall, and they said that the head lease, which was going to represent a significant portion of the development, was it $35 a square foot? And that number is just out of the air. When the actual head lease was about $12 a square foot. It would make a heck of a difference in terms of your value of the property, because what happens is you take that income and you capitalize that income. When your spread doesn't make economic sense, someone's going to lose a lot of money. Now, it was incumbent on the appraiser to recognize that a head lease on a significant portion of a retail space, that these AAA covenant tenants typically don't pay market rent on the same per square foot basis as the smaller people in the building. These are the drawing cards, the magnets. They usually get deals. This is why, for example, Eaton's and Simpson's and stores of that ilk, when they were anchoring major malls, they were having their rental income augmented or supplemented by the smaller retails within the plaza. But let's face it, how many people would have went to Yorkdale, or to any of the other major malls if there wasn't a Bay, a Sears, one of the big stores there? Everybody would still be dealing with the neighborhood market. Now, where the appraiser comes in this is, once again, the appraiser must understand the type of property being appraised. What are the units of value that should be explored in terms of retail commercial space? If you have an appraisal done and there's only one approach to value, that means you're hanging everything on one approach. If there are other approaches that should be developed, develop them. For example, what are the units of value employed in a purchase decision? In a house, it's pretty basic. It's an overall price. And you look at one house to another house and say, is this reasonable? But if you're involved in malls, office buildings, the more important consideration should be how much income are you generating? And how much of that income is net income? What are my expense ratios? As Mrs. Cody was saying when she did her discussion up here, some plazas may look the same, but heat loss calculations, your operational costs are higher. You should know exactly what the units of value are. A good example of fraud occurred in the United States with the savings and loan industry. Are people here aware of what went on in the States? Billions of dollars. And the reason that most of the problems came through was the property was never appraised. People were coming in with agreements of purchase and sale. They were misrepresenting, and nobody went out and checked. It was just carte blanche. You say it was worth $250? We agree. Here's your financing. Then they go out. There wasn't even a building on it. It would be raw land, swamp land. We've all heard of those fiascos down in Florida back in the early days. And closer to home, the great apartment flip of 1982. Do many people remember that issue when it came into Toronto? It was devastating, and it was in the papers for a long time. And a lot of people went down, and we're probably still paying some of the debt today. It cost, as you can see and hear the sequence of events, there was 10,931 rental units in the Grey Mac portfolio. And this property was purchased for $270 million in October of '82. Grey Mac then resold the property to Kilderkin, that was Bill Player and his group, on November 5 for '82 for $312.5, and Kilderkin immediately resold the properties for $500 million. That's quite a change in value in a matter of a few short days. And when you think about it, aren't apartment buildings subject to lease? Isn't a lease usually of longer duration than 1 month? So what happened to that income stream over that period of time? It remained stable. So unless this portfolio was grossly undervalued to start with and was now at market, or somebody was really manipulating numbers, the reason that we had the problem was that they'd only used one approach to value. And I guess the other reason that we had such a big controversy, if you think about it, back in the 80s, was that it was being sold to Saudi Arabians. And we thought, oh my God, we're selling our country away. Nowadays, Omer's bought the Cadillac Fairview, and it was just done in the last little while. Didn't even hit the newspapers because they're homegrown. But had we sold it to any other investors, there may still be ripples today. I guess the thing is that we try to do, and going to form part of the presentation, is how could that flip have been identified and stopped? And, you know, it says down on here at the end, although there were many subplots and factual twists, I mean, I asked someone to send me the documentation. It's just reams and reams. It's boiled down to the fact that there were factual twists, there was unsupportable hypothetical assumptions, collusion, improper lending appraisal practices, and these were all the root causes of the grief. Okay, in recent years, we just had this come down the pipes, I guess, within the last 5 years. Confederation Trust Company, remember they had the nice big offices up on Bloor? They aren't there anymore. They got involved in lending on multi-unit residential buildings. Anyone buy those for the tax deferral basis? It was something that, at the time, it made a lot of sense. The government, nobody could build apartment buildings. They went to private investors. The private investor put low money down on these things. They were rented out. And at the end of the day, everybody thought there was going to be property appreciation, there was going to be a reversionary value, and everything was going to be fine. Unfortunately, the recession came. Rental rates didn't go up. Property values went down. People who put $1,000 down on $100,000 properties now had to carry $99,000 mortgages. Very little rental income. A lot of them walked away. And when Confederation Trust tried to recover on the over-leveraged properties, people declared bankruptcy. If you have deep pockets, you're going to lose. The private investors walked away, and the developer, he had so many limited companies and numbered companies, no one could ever get to him. No matter how hard they dug, they couldn't get to the developer. He walked away with a pile of money, but Confederation Trust went down. And fraud currently exists in the marketplace today because of subtle changes in the Bank Act. At one time, the Act read that an appraisal must be conducted whenever a property changes hands or mortgage money is put on it. The bankers got together, and I guess they put in the word may. May and must have two different complete connotations of what happens. Under may, they aren't being done. Now, where the problems arise, does anyone remember the TD mortgage fraud that occurred up in Markham in the last little while? I have at the back of the and we'll just go over this quickly because it just, as I say, no matter how sophisticated we think we are, this is not in your handout. I've alluded to it, and I couldn't find the documentation at first, but I finally did. Basically what happened here, and I mean it was fairly sophisticated, but it was something that could have been stopped very easily. What happened was this group of people who they're trying to track down now basically went to the super mailboxes and intercepted mail. You know, every month you get these little mortgage statements from the bank, and it's clearly written on it, TD Bank, Royal Bank, whatever, and you're getting your mortgage statements. They come out quarterly, semi-annually. Well, these people intercepted those. They took them to the bank. They said, they came with that mortgage statement and a new agreement of purchase and sale saying that they bought the property for significantly more. They were prepared to renew the existing mortgage. In fact, they would like to increase it. The bank never asked for an appraisal. They never contacted their registered owner. In their greed and avarice to make more money, they gave them it. These people took it and ran. All of a sudden, the homeowner at home, he starts getting information, you haven't made your mortgage payments. You haven't done this, you haven't done that. Well, the bank transferred the title over to these other people, gave them their mortgage money. The homeowner at home, I guess he thought he was getting a buy. Ultimately, someone says you're in default 2-3 months. That's how the fraud was discovered. Now, according to this, that over $1 million of fraud was conducted on approximately 8 properties. The cost to the bank would have been under $1,500 to have those properties properly appraised. Rather than spend $1,500, they lost $1 million. Actuarially, this makes sense to them. It doesn't to me. But that's how easy a fraud can be run through. Okay, now in terms of appraisal, and I don't know how many of you were at the last one. These are the three approaches that are available to the appraiser. The cost approach, the direct comparison approach, and the income approach. Each of them has merit, provided they're being done on the correct type of property. And I would also suggest that if you're employing an appraiser and they're doing appraisals for you, you want to see two of these in the appraisal. Remember what I said very early into the presentation, one of the reasons for the great apartment flip, it was basically predicated on cost. Cost is not how the market typically buys properties. They buy it on replacement, principle of substitution. So if you are ordering an appraisal report and you're only getting one approach to value, there's a real strong possibility that you may not be getting all the facts and you may be making a mistake. If you're a lawyer and you're involved in litigation and you have an appraisal in front of you with only one approach to value, you should immediately smile. You've got them nailed. Because if there's anything wrong in that one approach to value, it'll show in the other two. They should be developed independently. Once again, reading them up, I guess the most important conclusion in this here is the final estimate of value. The important thing that anyone should do when they're developing an appraisal is you develop each approach independently. Do not take the data from your income approach and cook it in one of the other approaches. If you develop each approach independently, do it logically and do it the way you were trained, you're going to arrive at a number. If that number coincides with one of the other approaches to value, you have a consensus. That's what you're looking for. If there is a widely divergent range, something's wrong. Find out what it is. You've either made a mistake in your primary or your secondary approach. Your units of value could be incorrect. Something is wrong. Always develop them independently. Once again, this is in the handout, so I don't want to get too heavy into it. It basically defines what is done under the cost approach. First of all, the cost approach should be used with a great deal of care and caution. The reason being, unless you're dealing with brand new properties, who can properly assess accrued depreciation from all types and sources? If you're doing a 35-year-old building on the cost approach, how are you going to account for the fact that you need new HVAC equipment? The electrical supply is probably substandard. The clear height is probably substandard. If you're involved in a retail mall, you're probably due for basically refixturing, new floors, new ceilings, whatever. Your cost approach won't pick it up. So unless you're dealing with a relatively new property, don't use it. It's just going to get you in trouble. But if you're dealing with new properties, it may be the only way to do it. I guess, for example, what would you do with Casa Loma in Toronto? How on earth would you appraise it? Right? There's no direct comparables. You have to go to the Rhine to get them. Income, Kiwanis Club has been losing its shirt for how many years? Yet that property is assessed under actual value assessment at over $16 million. You can't tear it down. They won't let you. How did they arrive at that number? You can't develop the site because you can't tear down the building. You can't replicate the building and it's not making income. Does it have value? What's the value? How do you appraise it? I would decline it. If you phone me, I'd say, no, sorry, can't do it. Okay? I don't know if anyone would take that thing on. I guess there's always someone who'll try it anyway. Okay, direct comparison approach. Without question, 98% of the appraisals that you're going to get will have this approach to value. The reason being, it best reflects supply and demand in the marketplace. Everybody understands it. It's a visual. Most people are visual learners. If I show you two identical anything and tell you they sold at the same price, you're going to buy into it. If I show you an apple and an orange and tell you they're the same, you may want to start questioning things. Direct comparison approach, without question, is the approach that's used the majority of the time, and specifically for residential properties, industrial properties, apartment store type properties. The reason being, these properties do not trade relative to their income or on the basis of income. They trade for intangibles other than that, although they may generate income. The approach to value up here right now, income approach, without question, one of the most important approaches to value when you're doing income producing property. People all over the world are buying property based on a return of and on their investment. If you are generating economic rent, if you have reasonable expenses, and your net operating income provides a decent return, people will buy it. And it's amazing, I explained to Elliott when we did this last time, we had a pan-Canadian convention. It was in Calgary. We had 7 nations appraised to Calgary Eaton Centre. We sent them pictures of it and their performance statements. And the 7 nations hit the thing all within a very fine tolerance. So it doesn't matter whether you're in Eurasia, Soviet Union, Australia, Canada, send the people the right information, they can appraise it and get it within a pretty tight degree. Okay, as I said back a few minutes ago, how could we have prevented the great apartment flip? By taking a little more time and effort and developing another approach to value. If anything would have happened back in the great apartment flip and somebody would have said, on direct sales comparison approach, this doesn't work. On income approach, it doesn't work. The flip would never have occurred. It couldn't occur. Nobody would have got the financing. Okay? Expert witness. This is, once again, where most times you're going to end up with your expert who has prepared rebuttal information and data on an appraisal report that you already have, who's going to support litigation. And what the expert witness is going to do is take the courts through your expert guidance and tutelage, through each and every section of your appraisal report, show why your data is much more compelling and convincing, why it's more logical in its thought, its processes, and how this data is much better than the other experts. And then, obviously, the defense gets a chance to try the contrary. The expert has special skills, knowledge, and training. You want to make sure that you qualify them. Some experts you get into court, you can't qualify. You can't use them. The expert must render a qualified conclusion derived from the evidence when requested to do so. But it's a fine line. He also can't be an advocate, can he? If you have an expert who's blatantly an advocate, you're in trouble. I think I went through this last time. I've lost my sequence of pages. One of these days I'll afford PowerPoint. Well, if I could find 11 of 11, which you have in yours, we'd be just about finished. Okay. Once again, I think it's important under an expert witness situation that the expert must prepare reports or questions for the examination of discovery. Lawyers sometimes need help in certain things. I mean, you can only master so many practices. So you have an expert, you have a professional. What you want him to do is tell you what are the strengths and weaknesses of his case and your case. And you've got to be forthright and honest, because an appraisal report, even prepared by the best expert in the world, is going to have opinion evidence in there that's going to be challenged. So you'll want to know that there is indeed ranges of value in there. I think the other important thing is you would like to have your expert in court with you. This is where I think a lot of lawyers actually have a falling down and a failure, because what happens is information you don't want entered into evidence all of a sudden gets in there because your expert isn't there. Typically, if you were to go into a Toronto courtroom right now, you're going to see pretty much the same parade of expert witnesses, trial after trial after trial. And most of these guys are pretty good showmen. They understand what they'll do. And when they look around the courtroom and they don't see anyone there who's equally eminent in what they do, they're going to try and make brownie points and bring in information that may be arguable. They wouldn't try it if the other expert was in the courtroom, because the first thing that the other expert should be doing is checking all of the information that comes through. And if there is a problem in evidence under direct, he should be making notes for counsel, for redirect and examination. You know, you said this. Did you really mean that? You said this as fact. Wasn't that really not fact? So never keep your expert out. Try and get them to work with you. I know it becomes a cost-benefit type analysis, but it takes an appraiser many, many years to develop the skills to be good at what they do. And in the brief encounters you're going to have with them when you're discussing data and information, you haven't picked it all up. And now you're going to rest your case on something where, I guess one of the cases in court that happened, and I found it particularly humorous at the time because I almost got nailed on it. Sometimes you get lazy, or you're not instructed to do something, or somebody's trying to save money. This was a court case that happened to me about 3 years ago. The most damning sale in the other guy's report, I had no reason how and why this property sold for what it did. I mean, it basically refuted all of the other evidence, but you could see that he was making a hell of a case out of it, and the judge was buying into it. So that night after court, I decided I better go have a look at this property, maybe even talk to the owner and see what I can do. And I drove to the site. And I looked at it and I went, wow, I wish I'd have had this in my report. Great property. I could have really used it. And I got out my camera to go take a shot of it, and a fellow came out of the house and said, what are you doing? I said, well, your property sold a few months ago, and it's now, believe it or not, involved in a court case, and I want to get some information. He says, it wasn't my house, it's the one in behind. So I went in behind, and sure enough, exactly what I wanted. Go to court the next day, the defense lawyer gets up, and he starts challenging me, and he throws the picture of the property down and says, what do you think of that? And I says, it's a hell of a home. I really like it. In fact, it blows our property away. And he says, well, what is that going to do to your appraisal? And I said, nothing, because it didn't sell. Here's the one that sold. Destroy this case. Just because you go out and do the due diligence. Never be afraid to send your expert out. Sometimes through the trial you're going to be involved in having to get extra information because they're going to bring something up. And your expert has to know what the testimony was to find the data to refute it. So at the end of the day, make sure that whenever you're ordering or commissioning appraisals, it's more than one approach to value. 2, that you understand the methods of valuation being used, the units of value, and the constraints of the data. And 3, your expert should be consulted throughout the trial, because he may find that one critical piece of information is going to turn it around for you. Anyway, I know it's been a long day, so anyway, that's the end of that presentation.
Thank you very much. Okay, we're going to take a short break for about 5 minutes. I asked it to be a short break because I've got some videotapes to show you, and I've got all sorts of other audio-visual material, and they've given that I was the chair only 40 minutes. I'd like to take an extra 5, so I'm going to take that out of your break. So if you could be back in 5 minutes instead of 10. Thank you very much.